Sir, tell me about law and caste in judiciary.
Law and caste in judiciary, particularly in the Indian judiciary, the judiciary is totally dominated by upper caste. Originally, the higher judiciary is totally dominated by Brahmins. It's an exclusive monopoly of Brahmins. Later on, the so-called upper caste people had to fight against the Brahmin domination. Forget about the lower caste, backward classes and Dalit. There is a huge fight, a constant fight against the domination of Brahmins in the higher judiciary.
In Supreme Court, okay.
In the higher judiciary, high courts and Supreme Court.
Okay.
So slowly these people could enter the upper caste. When once after the independence, when the political power is slowly snatched away by these upper caste people, particularly this in Andhra Pradesh, Reddis had come up, and in other high courts and Supreme Court, non-Brahmin community, when once the political power is concentrated in this higher caste people, slowly the Brahmin domination in the higher judiciary also came to the little lesser extent, and these people were slowly occupying the place of Brahmins,
Upper caste people.
The stage at the time of the backward classes and the Dalit has not yet come.
Okay.
Still, they are on the fringes of this judiciary, particularly the higher judiciary. Originally, at the time of independence, I will give you the brief history of this judiciary. When the Britishers ruled in this country, even the lowest position of a magistrate, the junior judge, magistrate was also manned by Britishers. The Britishers were under the impression that Indians, including the Brahmins, were not fit to become judges. They had no capacity to judge. Even the Brahmins.
Okay.
So that's why they had to import people from London,
Okay.
from England, to be posted as magistrates.
Okay.
Forget about the High Court judges and the other judges.
Okay.
So that was the attitude of Britishers at that time. So the Brahmins, in initial stage, they had to fight for an opportunity to be appointed as judges,
Okay.
which was denied to them.
Okay.
You think of a stage where Brahmins were also denied to be appointed as judges.
Okay.
Imagine what would be the state of non-Brahmins, backward classes, and the Dalit. So
Okay.
that was the stage. Even K.R.Narayanan
Okay.
he was on record to show that by this practice of denying the opportunity of Brahmins to become as judges, you are dwarfing Indians.
Okay.
They are stunting the growth of Indians.
Okay.
So please give us a chance of appointment to become judges. So slowly they had to fight.
Okay.
Brahmins were fighting. Brahmins had fought. They got some opportunity. They got some share. So thereby, at the time of independence and even after independence, majority of the judges were Brahmins. Majority of the judges of the Supreme Court were Brahmins. Majority of the judges of different high courts were Brahmins.
Okay.
So from the domination of Brahmins,
Okay.
then again the fight started by the non-Brahmins.
Okay.
Non-Brahmins, particularly the dominating community of the non-Brahmins.
Okay.
For example, in Andhra Pradesh, Reddis and Khairlanji.
Okay.
Other similar communities, Jats, other Kshatriyas, other people, other castes. So the fight went on for some time. So slowly they could enter into the higher judiciary, this so-called non-Brahmins. When the non-Brahmins started fighting for the post of judges, the Brahmins were openly telling that you non-Brahmins are not fit to become judges. What the British were telling against the Brahmins, the Brahmins repeated the same against non-Brahmins. So the fight of the non-Brahmins went on. Now there is a stage, because they say, they were telling that you people have no merit. You people have no capacity to judge things. You people have no concept of law. You non-Brahmins are not fit to become judges, since you have no merit. So the merit at this stage started with Brahmins at the time of independence, came down to non-Brahmins, and the so-called merit stopped in Andhra Pradesh, at least with Reddys and Kamas. Even the merit has not reached the Kapus, the other dominating community in Andhra Pradesh. So forget about this BCs and SCs. Right from the beginning, there is no reservation in the appointment of judges in the High Courts and Supreme Courts. They were refusing. Though there was a strong demand for it, the Constitution, there is no provision for it. In spite of having this provision in the Supreme Court, but even for norm's sake also, there is no norms of taking non-Brahmins, backward classes and scheduled castes, scheduled tribes as judges. So now, since there is no reservations in the higher judiciary, you don't find sufficient number of backward classes, scheduled castes and scheduled tribes in the higher judiciary, that is in the High Courts and Supreme Court. So this is the role played by the caste in the appointment of judges in the higher judiciary. So now, let me take the example of Andhra Pradesh. Andhra Pradesh, now the present strength is at about 43 or 49. So 50% should go to backward classes, scheduled castes and scheduled tribes.
That's a law.
No. General principles of reservation. There is no law of higher judiciary.
Yeah, on reservation,
On reservation.
Yeah.
So there is no question of reservation. But if you take the reservations in the other fields, 50%, that's the maximum limit. So 50% comes to 49, so it's almost 25. 24.
Yeah.
SCs and BCs, STs put together, there should be 24 at least minimum in the High Court of Andhra Pradesh. But hardly we are having 2 backward class judges, 2 SC judges, no representation from ST. Practically there is no representation from ST in Andhra Pradesh High Court. Minorities there are. There are 2 Muslims. Yes. But unfortunately, the establishment or the administrators think that minorities means Muslims only. But there are Christians, particularly in Andhra Pradesh, there are Sikhs and Buddhists elsewhere. But in Andhra Pradesh, there are Christians, substantial number of Christians. But minorities, they only consider Muslims. So now presently there are 2 Muslim judges in the Andhra Pradesh. From the history of the establishment of Andhra Pradesh High Court, only one advocate belonging to scheduled tribes was appointed. He retired, and thereafter there is no appointment of SC at all. So almost 50 means the SCs should be represented by 8. We are only having 2. 4 should be given to STs. There is none. So this is the composition of Andhra Pradesh High Court, and this is the role of or the power of the caste in the higher judiciary. Women also, there is no proper representation in Andhra Pradesh High Court. At least the judiciary or the appointing authorities are not conceding the due share to the women. They are all women. They can get Brahmin women if they want. Brahmin women are there. Reddy women are there. Kamma women are there. They can give it to the women. But this male chauvinism in the higher judiciary is also so powerful that very reluctantly they have appointed 2 women judges in Andhra Pradesh. Now we are having 2. At least they should be half, at least 1/3, but no. So this judiciary is not prepared to share the judicial power, administration of justice with backward class, scheduled caste and scheduled tribe, minorities and women. So these people have to fight for it. Constitution says equality. The soul of the Constitution is equality and equal opportunity. Unless opportunities are given, no one will be in a position to prove his merit. So you give proper opportunity and they will prove their merit. They will excel in the field. So therefore Constitution says equal opportunity and equality. So that is totally denied in the appointments of higher judiciary now.
So one question is about this merit. There is a different discussion about merit, that certain fields of Indian Constitution also, they say certain fields are exempted from reservation policy because they say it spoils the reservation. Even now they talk about the medical and reservation. So that what is your point of under the Constitution and your law experience? How do you explain this merit with what the argument the anti-reservation people talk about?
Particularly as far as merit is concerned, merit is nowhere defined. No meaning to merit is given so far by the High Court or the Supreme Court. Just they say merit means merit, that's all. What is the merit? What do you mean by merit? No one is in a position to define merit. Scientifically established merit, 2 + 2 is equal to 4. That's a mathematical formula. There is no such formula to explain what is merit. Constitution does not speak about merit. That is the invention of the Supreme Court judges.
Which one is invention?
Merit.
Oh, that is invention of Supreme Court.
Invention of Supreme Court judgment. Constitution never speaks about merit. Constitution speaks about, particularly in certain appointments, they only say suitability.
Okay.
Suitability is different from merit.
Okay.
So merit is invention of the Supreme Court judges in order to deny the opportunities to SCs, STs and BCs.
Okay.
Since fundamentally it is decided by them or established by them that the backward class people, scheduled caste and scheduled tribes have no merit, so they are not fit to become High Court judges and Supreme Court judges. That's all. So you cannot, even one judgment, Supreme Court judges, in one case, they said that there is nothing like merit. You cannot establish that there is no yardstick for merit. You cannot measure the merit. Merit is not the marks scored in your examination. Totally merit is a different aspect. So you cannot deny the chances or the opportunities of any class by branding them as non-meritorious or lack of merit. So this theory of merit, this anti-meritorian or the anti-mandal agitation is only, it's a clock to deny the opportunities of SCs, STs and BCs to get there, in order to get their due share in the administration of justice or in the other administration.
So many people say, for example, in lower judiciary there is reservation, if I am not wrong. Then since the lower judiciary there is a reservation, and the process of selection of judges is a very transparent or something, and they can compete with the other people and they can apply and they can get a job. People say that you come with a qualification, 100 people come, Chief Justice or 1 or 2, we choose. How does this, why it's, they are not capable, people say. How do you define this?
Lower judiciary there is a reservation. Of course with great difficulty we got it. Even in the beginning of lower judiciary, that is district level, district and taluk level, there was no reservation earlier. With the great difficulty we fought for it and got it.
Which year it was?
Somewhere about 70s. So there is no reservation for High Court and Supreme Court. I'll tell you an example. Let's say because of there is reservations in the lower judiciary, there is a written test and an interview, oral interview. Written test nobody can stop them, but in the oral interview they got their own mechanism to deny the opportunities of this class, and they are denying it. I will give you the latest example. In the latest recruitment of junior civil judge, junior civil judge, in the written test, the scheduled caste particularly excel. They come more in number than required. In the interview, they scored higher marks. In the district judge and selection to district judge, I am speaking. In the selection to district judges, let us say there are 6 posts. 2 posts or 1 post reserved for scheduled caste. Backward class and scheduled caste outnumbered the caste windows. In the selection, even the interview also, they scored higher marks than the caste Hindus, the scheduled caste and backward class put together.
Okay.
I think there are 6 vacancies. I am not sure of the vacancies, but in the entire 6 vacancies, they could not find one Brahmin candidate who came with the merit,
Okay.
the so-called merit. So these people, they are all proved to be more meritorious than the upper caste, including Brahmins.
Okay.
So in the selection committee, a Brahmin High Court judge who is having a power to maneuver the things got to it to scrap the entire selection list
Of districts.
of the district judges because he could not find one Brahmin who come up in the merit. In the merit, forget about reserved seats. In the open merit, backward class and scheduled caste scored higher marks. Since he could not get one Brahmin candidate, at least one, so he saw to it on some technical pretext. They got the entire selection list cancelled, and they got again for fresh selection. So this is how they outdo the things. This is how they say that we want merit. These people proved merit. Yes, we are more meritorious than these. They cannot show that these people are not having merit. So the only other way is by some proof method. You cancel it and get other. Now, even the next selection also, probably they invent a method to see that these people could not come in the open category list. I don't know what mechanism they developed. So this is how this caste operates right from the beginning, in the inception of the appointments of judges in the lower category as well as the High Court, and entire profession, legal profession is dominated by upper caste. Once it was the total 10% domination of Brahmins, you don't find any non-Brahmin advocate. All Brahmins dominating the entire legal profession. Slowly, as I was telling, in the appointment of judges, slowly these upper caste Hindus, non-Brahmins, slowly they could enter into this legal profession. Ultimately, the legal profession depend upon the social background, political background. So once the political power is snatched away from Brahmins by the non-Brahmin upper caste Hindus, so they could get the domination of the profession. so they could enter into the profession. Slowly the dominance of the Brahmins was lessened, reduced. Now the entire legal profession is dominated by upper caste Hindus and Brahmins. These people are struggling to enter into the profession, to sustain there. Having entered, it's difficult to sustain. It is very difficult to sustain for backward classes. We imagine the state of affairs of scheduled castes and scheduled tribes. There is no social backing for them, no economic backing, no political backing. Unless you have a social backing, economic backing, and a political backing, you cannot establish or shine or prove your merit, so-called, in the profession. This legal profession is totally different on the backing given by your society, the community, and the political. So this is the situation. And when once any person who could stand and prove his mettle in the profession, legal profession, is one exemplary instance. It's very difficult to get into and retain there. So my experience is totally different. I had to struggle from the very beginning. No doubt I have some political and social backing. My father was an MLA. Earlier my father was a teacher. So my father was an MLA. I had a political backing. I had a social backing. Since I was a student belonging to a particular social background,